Okay, I'd like to call the meeting to order. Welcome everyone here. We'll stand for the Pledge of Allegiance. Pledge of Allegiance.
Of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Okay, I'll just follow the agenda. I notice we do have a spot for public comments. Any general members? I don't think we have anyone here. Nobody's filled out a card or anything. So we'll move right on to our new business, proof of notice, meeting posted by the clerk. New business, request for reconsideration on the following petitions, 3 minutes per party. Does our attorney want to say anything before we get started?
Yeah, just to walk through the process.
Okay.
So the way this works is pretty straightforward. Each side gets 3 minutes to present. The petitioner, well, in this case, it's the petitioner because it's the party who files the request goes first. Then the property appraiser gets to respond. The board may ask questions, and that's really the process.
Okay. Thank you. Any questions from the board? All right, our first petition is number 2025-00054.
I don't believe he's present.
Okay, they're not here. Okay.
Okay, my mistake. So, yeah, if the property appraiser wishes to present, of course, this is the time.
Yeah, come on up so we can get you on the mic.
George Maslino, Property Appraiser's Office. Do you want me to go through my petition, or just, if I just stand on what we submitted? How do you want to do this?
And this really goes for, I would suggest just stating your case. You may want to give some background for the board.
Okay. This was a case of a homestead application. There was a question as to their residency documents. They were all after January 1. Florida law requires that you own, occupy, and use the property as your permanent residence as of January 1 for a homestead. The petitioner's information was in March. I think he converted his driver's license to March. His voter's card was March. And at the time of his application, he was still his vehicles were still registered in New York. So we felt that because of that residency document didn't change, he wasn't entitled for the homestead as of January 1.
Okay.
And,
Was that one of the numbers that we had on here?
yeah, it's on
Yeah,
the
the
agenda.
very first one,
The
00054.
And if I may.
I have questions. I have a couple of questions. So. Just more procedural, kind of stupid questions, but I'm good at asking those stupid. Yeah, okay. I have a question, and maybe the attorney, maybe. Don't be shy. Now, is this something that went to the special master and they ruled against you, or why do you have to be here? If you deny that, it's not automatic. Why do you have to be here?
Yes, the special magistrate ruled in the petitioner's favor on this one.
Really? Oh.
Yes. That's
Now-
why we're here.
Okay, that's what I thought. That's what I thought. Now, is anyone here going to give the other side?
They were
Does-
definitely given notice, but
Okay.
they appear not to be here.
Okay, that's right.
Okay.
Okay, thanks. Okay. All right, let's bring it to the board. Any comments, questions, motions?
Yep,
Yes,
I'll wait until you guys go.
that was the only question I had.
Ms. Atkinson?
I was,
I
just wanted to
respect.
clarify, everything had to be changed, driver's license, resident, everything by January, and it didn't happen until March. Is that correct? I'm sorry, George, I guess I'm asking you the question. No, that's okay.
We're going to get your steps
That's
in
okay.
today. That's a good way of getting those.
That is
those-
what the record reflects.
Yeah, okay,
Right,
yeah.
so this person, January was cutoff date to change all their documents and to be there. And it appears, well, that they didn't get it done until March.
Correct. Yeah.
Did they-
That's simple. Yeah, please.
The statutes provide a list of documents that the property appraiser may consider when you're filing for homestead. And if you all file for homestead, driver's license, vehicle registration, voter's registration, things like that. And all those documents were after January 1, significantly after January 1.
I can't understand why the master
So when,
That's right.
when we say that they came in after January 1, did we get them or after January 1, but they were done and completed by the petitioner prior to January 1?
No, ma'am. The petitioner filed timely, but they did not transfer those documents from New York to Florida
Till March.
till in March. Yes, ma'am.
Okay, thank you.
But he did have his electric and all of those things were in his name in
I believe,
here.
yes, because it was a house he already owned.
And he did not own a house up in New York, is what I was
I
reading.
believe that, I think so.
Yeah, so he did not have a residence in New York, only had a residence here. Didn't have the driver's license and those things here, but then did have the water, electric, and all that stuff here. That may be where the special magistrate was going, is that, sometimes it takes some time in between. I don't know. That's all.
My recollection of the case is the petitioner's owned the house in Florida since 2023, has been going back and forth from New York to Florida since 2023. And I believe his comment about changing the documents was he didn't know, or he was getting get around to it.
Okay.
And I think that's in the package you have there.
Okay.
Just for the board's edification, my recommendation is to grant this request, whether it's circumstance or not. The record really does show that on the evidence, he doesn't have the January 1 date. So and really the findings of the special magistrate, I don't understand why it wasn't denied to begin with.
Is there, is the special magistrate have a report that they say the reason behind that?
It's pretty short, yes, but it's short. And this is a very good special magistrate. I'm just going to chalk this up to an honest mistake, because I really just don't see how the evidence could sustain granting homestead. It's just not there.
Okay.
So I guess for me, while I don't always like to be black and white, there's gray areas, but in this case, it had to be done by January, and it wasn't. And.
Well, and I think, if I may, I'm sorry.
Yeah.
For me, what it is that not only does it need to be done by January, but they were aware of this. Were they aware that the property appraiser was saying no and that they would have to be here to argue their point?
I don't know if that came up. I mean, every taxpayer is presumed to know the law, so that they're required to know of the requirement, whether they're actually aware of it either way. So,
But
Ignorance is not an excuse.
yeah.
But to know, right,
Yeah.
but to know that I won in special magistrate, and to know that is there a time where the property appraiser says, hey, we're going to go ahead and contest this, was that ever sent to him? So would he think when he was inside that meeting that all of a sudden I've won my case, and now he doesn't know that he's supposed to, where's that notification go? Do we email him saying his case is coming up? Like, where?
Well, before it got to I think this was a late filed application to begin with.
Mhm.
So there really wasn't anything, before that, there wouldn't have been anything either way. It was denied by the property appraiser, he appealed to the VAB, the special magistrate recommended granting it.
And he was in
And
that
now we're
meeting,
here.
right?
He would have been, yeah, he was at the hearing, yeah, with
Okay.
the special magistrate hearing.
Now, that brings up something.
Go ahead.
So at that special magistrate's meeting, would he have been aware that it was going to go his way? Or does he leave that meeting with the special magistrate not knowing anything and waiting for the,
It's the latter.
It's the
The
latter.
special magistrate doesn't announce the recommendation at the hearing.
How does that person find out that and the reason I'm asking all of
Please
these,
do.
just so you know,
Yep.
is because a lot of the recommendations in this space is what I was going to try to talk about today.
Yep.
So the thing is that how does he know? So he wins the case, or he loses the case. He may or may not have been there, but we don't.
He doesn't get a decision.
He
at
doesn't
that
get a
minute.
decision. Does he get notified of that decision?
Yes,
Then does he get notified that the property appraiser is going to say no, and that they can come to this meeting?
yes,
And they know the date of that?
yes.
And that goes to them.
Yes.
Okay, then you're right. Like, you don't show up to argue your point and you know the property appraiser's coming. It's a difficult thing to do. I agree. Thank you. I'm sorry to go through all that.
That's
Just
okay.
some of that back and forth is, you know what I mean? That's what I was
Yeah.
talking about, so thank you.
And for me, now I understand the process a lot better. So that's why I asked
Yeah.
that question. Thanks.
Mr.
Okay.
Altman?
Yes. Okay, any other questions? What is the will of the board?
What would be the right way to say, to structure the motion?
If it's a motion to grant the request, which would deny the petition, in other
Yes.
words, no homestead, it would be a motion to grant the request.
I'd like to make a motion to grant the request.
Second.
Okay, there's a motion and second to grant the request of the property appraiser. Any discussion?
One question.
Yes.
I'm sorry. Okay, so one question. We're denying the homestead exemption request for just 1 year, right?
Right,
The guy refiles and?
Yeah.
Okay,
yeah.
Yeah,
thank
and I
you.
mean, that's where I think Ms. Atkinson and myself is that, like, look, if he was willing to try to do it, that's great, but if he wasn't, you know what I mean? Like, you have some, and it may be that he wasn't here when it was happening. I don't want to speculate. I think it's I think the property appraiser's correct in this one.
Okay, any other debate? All those in favor signify by saying aye.
Aye.
Carries unanimously. Okay, we'll move to the next item. It's 2025-00066.
Hi, my name's James Paget. I'm here, I guess, because I received notice that a consideration. I applied for first responder exemption, was denied, partial denial due to my employer's certificate stating that I had left my employment under retirement. So with that being said, I petitioned it, went to a magistrate hearing, did a new format of my evidence and everything, particularly on that one certificate to prove that I did not leave because my workers' comp doctor had not allowed me to go back to work as per the fire chief, gave me a specific date. With that being said, anyhow, I went to the magistrate hearing with evidence only under that. I was not totally aware of how the Florida statutes work towards that because the ladies at the tax office had just told me about it. So I went and did all my homework, got all the certificates, turned them in. Anyways, moving forward, went to the magistrate hearing because I was contesting the way the format of the certificate was, because she had signed, agreed, saying I was partially or disabled, but she had put into comments that I had retired from there. Anyways, I got a denial on that. I wasn't really sure how the process worked, so I sent a reconsideration for it. Since that was basically during the holidays. A lot of this stuff was going on. It was hard for me to get to my workers' comp doctor, but since then, I had recently went to him, asked him for a certified letter, and when I received that certified letter, I had taken it back to my employer, and she had filled out a new employer certificate on that.
Okay. Are there any questions?
Yeah, because to be completely honest, Mr. Altman, I always look to you to kind of give guidance through these because you have an experience in here.
Right.
So I know that you're the chair and normally everybody else is supposed to go first, but I was looking to see what your thoughts are and then ask Mr. Thurowitz what his thoughts are and stuff like that. That's all. Because I have mine, but.
I can make a suggestion. Certainly, the board can recall the petitioner for questions after the property appraiser has an opportunity to present it if the board has questions. So it may provide more context to do it that way, but it's
Yeah.
it's up to the board.
Let's hear the other side, that I do have a number of questions.
Okay, good.
I guess I could ask one of them now. As we stand today, are you retired or are you?
Well, during my employment, when this incident took place, I was what they call I was in the drop. And
Okay,
yes, at today's date, I am retired because that's an income. And when you're in the drop, if you leave your employment, your drop don't do nothing for you. It just sits there. So yes, I did start collecting. And I did show proof that day with a document. The day I left my employment was May 6th. That's when the workers' comp doctor said I couldn't go back to work. That's when the fire chief said I'm to turn in my gear by May 7th, and that they would proceed with the paperwork. And May 11th is when I signed to start receiving my retirement, which it takes a month to do that.
Right.
Before you start receiving it. But I presented all that evidence and stuff at the magistrate hearing. And then basically what her decision was, she went on to some of the other statutes that I wasn't aware of that I kind of have fulfilled now. It's just that I got that paperwork with me. I just don't know if it's acceptable by you all with this or what. Because I do have a doctor's certificate and I do have a new employer certificate.
Are we able to accept that?
Yeah, if I can maybe shed some light on it. So I think what the petitioner's saying is he's got some new evidence. He's got a certification that he didn't have at the
Yeah,
hearing.
that I think that would basically cover my partial denial that I received back in June.
Yeah, so the problem at the hearing and the reason why the magistrate recommended denying this, it's a technical statute.
Yep.
We get one or two of these every year. Every one of them is unfortunate. Statutes have to be strictly construed. In this case, the certification presented at the hearing, it's a cardiac issue. And let me read from it because I want to get it right. So for cardiac events, the statute requires certification from a treating cardiologist linking the event to a line of duty non-routine stress within 24 hours and ruling out pre-existing vascular disease. In this case, he did not have the treating cardiologist certification that met the requirements for a cardiac-based disability. The statute has problems, but under the statute, the special magistrate, in my opinion, made the right recommendation. And while perhaps it would be, it would make sense to hear the new evidence at this point, I'm going to recommend against it. The board should not, really cannot consider new evidence that wasn't presented at the hearing. So,
And just so you know, I understand that because all the documents that were sent to me was saying that no new evidence could be presented, but like I said, I went to that magistrate hearing for a denial to prove that I did not retire. It didn't specify any of the other statutes, which I wasn't, like I said already, I wasn't aware of until that magistrate hearing. Then I went back and did my research and found out what I had to do on my own.
Just a quick question. So what are his options to get this new evidence heard? What can he do?
Well, he can certainly, assuming that the final decision from the VAB denies his petition, he can appeal to the circuit court. Whether the outcome will be any different, I can't say.
But with new evidence that then fulfills what we needed.
Yeah, but I don't think that would help, because that evidence cannot be considered at this point. While I don't enjoy saying it, I think
Yeah.
the only option is to reapply next year.
We're sort of
But
sitting,
I can't give legal advice, that's just my impression.
we're sort of sitting as an appellate court, just like when you go to the circuit court. You don't retry the case, you look at issues of law.
Yep.
And so we can only look at the issues that were presented at the time of the hearing.
That's a good.
But you did say that he could redo it next year? Did I just
Of
hear
course.
that?
Yeah, he can certainly apply next year.
But let me ask this. So if we're not allowed to take any evidence, then why is it that we allow to hear an individual come up and give testimony and take their testimony in as part of evidence? And if so, even though we don't have the documentation, is there, because again, the process where if the man who is a normal citizen receives a document that says, this is what I am being denied for, then he comes to that and says, I am responding to that, but then finds out at the meeting that there's a host of other statutes and doesn't understand 100% that, and I know how difficult those statutes are for the average citizen to get
They're
through and
very
understand.
difficult to read. I do
So
agree.
I think is there a case inside of the statutes that says that if a person is being charged for X or saying denied for X, comes back and fulfills that X, but then is told otherwise, because the formal letter that probably went to him did not have any of the other statutes that were presented? So is that, am I following the right?
Well, I guess what I can say is, when they come, when petitioners, when the property appraiser presents before the board at a meeting like this, certainly they can recite whatever evidence is in the record. They can present argument. But really, the purpose of reconsideration and the extent of the board's discretion is if the magistrate did not apply the law correctly, and that means to the facts in the record. So what Commissioner Altman said is very accurate. This is similar to an appellate court where evidence, the time for that was at the hearing.
But if the citizen didn't know, and I know you're not the one that, you're just giving the information, if the citizen did not know that those were other areas that may need to be fulfilled, then we lost the opportunity to notify them and for him to actually make an argument back. And so it's kind of a loophole that falls into place. So now he comes before us, has evidence that we're not supposed to see physical evidence, but we can take his testimony evidence?
Well, not if it presents new facts, which
Okay.
he does. I mean, I'm not
I see
saying.
what you're saying.
Yeah, so, if it's, whether it's testimonial or documentary, the board can't consider it.
Yeah.
They may present it, but the board can't.
And I'm
consider
sorry
it.
to the property appraiser for not giving you the opportunity to come up here yet. I'm sorry. I'm just working through some of the processes, man.
I don't know about that, but I'm sorry with that thing. Basically, what he's saying is what is kind of like my argument, is that I went because I got a letter for denial, a partial denial I left my employment for retirement. And yes, it's my ignorance for not knowing the statutes, I guess. You could say that. But his point is pretty much exactly what I'm trying to explain. Yes, I understand you're not allowed to take new evidence and everything, and my only alternative is to reapply. And that's basically, I'm here to argue whatever, I don't get it.
And for me, from the scope of, he came to a special magistrate meeting under the idea that this is what he needed to defend himself. They presented new evidence at that meeting that said that he did not, okay, well, if you met this, then we're going to apply these that he didn't know about. So now there's no opportunity for him, because at that meeting is the last meeting, to actually present any documentation. So if he didn't bring it from his car or anywhere else or have the opportunity to present, I really have an issue with that. You know what I mean? But we haven't heard from the property appraiser and stuff like that, so.
I
Go
do
ahead,
have,
yes, ma'am.
if I have, sir.
Yeah.
So my question is, this piece of evidence that you have, that we haven't been able to see yet, have you seen it? Just,
Not that I know of.
No,
Okay.
he hasn't
Yes.
seen it because
so if you gave that to us today, then how do we know that that fulfills the previous whole?
Well, it may not.
Exactly, that's how would I know if it did or did not?
For better or worse, and just to be perfectly direct, it doesn't matter. The board should not, and I say should, cannot consider new evidence.
Right.
I'm not saying this is the right moral decision or outcome, but legally, it's not a difficult one.
And just for process, today is not the final day that we have to make this decision, right? Or is today the day we make it?
Well, for all practical purposes, this is the last opportunity for anyone to do anything with this case other than approve the recommendation. There won't be any other, requests for relief. So this will be it, practically
This year,
speaking.
not forever.
For this year, of course.
Is there an avenue to request and again, processes, right, just playing around here. Is there a request for us to ask the property appraiser to take a look at what's been presented, or no? Is there a loop back to them saying, hey, guys, like,
That's a good
he's
idea.
presented some new stuff. We're trying to head off a man who obviously feels justified in what he did, had a situation inside the magistrate. Is there a way to have that? Is there a path for that in this?
I would recommend against it.
Okay.
The board is required to sit neutrally.
Mhm.
And while I know it's not the intention to be favoring one side or the other, I get that, but I think that it could be interpreted that way. The board's role is to consider the evidence and apply the law only. So perhaps that in isolation wouldn't violate any particular rule, but as a practice, I wouldn't recommend it.
And I can understand why that's in place, right? The amount of energy that somebody can do after the fact and make arguments and do all that stuff is there. I just feel that under the circumstances, if your guidance is that we have to make decisions based on the old evidence, that's one thing. But when an individual's told by statutory law, this is what he has to file, is the statute in the same subsections, or is it just an entirely other subsection that they brought? You know what I mean?
It's all
under the same-
196.102.
And then it's
all
ABCD.
self-contained. I mean,
It's all A, B, C, D, E.
Yeah. it's all-
But they only said one. Okay, I'm sorry. Go
It's
ahead.
okay. I have one more question. So if we deny this today, is there anything that the property appraiser can do to change the decision that has already been made? So my question is if we say, no, we have to follow the law, can he go back to the property appraiser and say, hey, look, I know I just got denied everywhere, but this is the truth, this is my document. Can the property appraiser change their mind, I guess is my question?
I guess
New
the
application.
honest answer is yes. Whether they would or not, it's really not my place.
Right.
So there's a place where the property appraiser can look at all of this and say, before the next time we meet, that this is
And
justified.
If I could, one thing, and this doesn't solve anything today, but every taxpayer is entitled to an informal meeting with the property appraiser. For
Could
multiple
I ask you a
reasons, that's a
question on
good
that,
idea.
sir? I'm sorry to interrupt
Well,
you.
if I could just finish my point,
Okay.
I'm happy to, but that's a great place, even if you don't get what you're ultimately asking for, to figure out what you might need. So I'm not suggesting that that helps at all today, but that is something every taxpayer is entitled to do, and I don't know exactly how those conferences generally go, but I would imagine that at least in a case like this, it might give the taxpayer an idea of what might be missing,
So you're saying.
before you get to the VAB.
Right, before they get to the special magistrate?
Yeah, before they even file a petition.
Okay.
Okay, could I ask you a question on that? Since the informal meeting, I did request one. What's your definition of an informal meeting? Can I ask you that?
I don't really have one. I think,
Is there one?
I would think that it
No.
would be a meeting face-to-face to explain what the statute is, what I didn't do and stuff like that, help. Because that's another problem I have is everybody I talked to, I couldn't get no answers in asking questions. I did request an informal meeting. The lady that contacted me, I was on the road, she left a message, so I called her thinking we could set up an informal face-to-face meeting. Her reply was, no, she's rechecked everything, and that's it, it's still denied. So I didn't even have a chance to go ask, what did I need at that point before the magistrate hearing, or anything like that?
Can you walk through that series of events? So you called the property appraiser. Yes, sir.
Yeah, or the lady that was representing the property appraiser.
Yes, sir.
I emailed a request for an informal meeting. And in doing so, I hadn't heard back, so finally I got a phone call. I was coming back from an appointment, and I was on the road. I listened to the message, I returned the phone call, and the reply from her was that when I asked her about an informal meeting, which to me, I thought it would just be like a sit-down,
Yeah.
face-to-face, go over stuff. Because I was trying to present evidence showing what the denial said about the retirement, not about the other statutes that I have fulfilled. But anyways, and she says that she went back and she contacted all that stuff, and she said it's still denied. So that was where it was left at. There was no setup to meet with her or anything like that.
Was that prior to the special magistrate?
Yes, sir, it was.
And at that point, did they?
Because that was my first step, was to request an informal meeting before you petition for a magistrate meeting.
And at that point, did they mention that any of those other statutes would be presented to you?
No.
Okay. And
Only
did-
thing it was is that basically, we stuck to what the denial letter says, that it was a partial denial from the employer stating that I left under retirement. And that she's went back and checked her system and all that stuff and it's still denied.
Okay.
And I know there ain't gonna be no record of it because none of the phone calls are recorded, but that's exactly what took place. Because I just thought that was, to me, in a way, it was unprofessional.
Did you ask at that point, can I have a sit down? Can we talk?
Yes, and she said there was no reason for it.
Okay. I think I
I
understand.
wonder, should we hear from the property appraiser's office?
Yeah, that's what I was gonna say. I think we've heard enough from,
Yeah, let's go ahead.
Let's go ahead and
Let's
move. Let's hear from the
We have,
property
may have more
appraiser. Thank you.
questions after result.
yeah, we might have some more. Just let's kind
Okay.
of fill in some of those gaps now.
This property was denied a first responder total and permanent disability because the employer certificate wasn't correct. And also under Chapter 196, 102, which what he files for, it lists several documents you have to have. And one of them is a certification from a cardiologist saying that the cardiac event happened within 24 hours of why you leaving. That was not presented. That's what he has now. This goes back again to January 1, you have to have your documents in place. At this time, he did not have those documents. So we had a denial for the employer certificate said he retired, he wasn't medically discharged from work. And also that the cardiologist report wasn't there. So that's why the denial. And that's why the special magistrate, excuse me, denied it also. Now, as far as informal conference, there, as the attorney said, there's no definition. We talk to people on the phone for conferences, people come in conferences. There is no statutory defined. A conference means someone has to sit across the table from each other. So he was spoken to, told that he was denied, and that's all I have for our side.
Is there, in the rules or the guidelines for the property appraiser's office, is there a statement that says maximum number of informal meetings?
No, sir, the statute
Thou
says.
shalt not exceed, kind of thing?
No, the statute says the taxpayer has the ability to have an informal conference with the property appraiser. It doesn't say 2, 7, 10, 11, it doesn't.
Okay.
Do you know, just off the top of your head, how many of those informals actually occurred in person last year by any
I'm
chance?
sorry, we've got 4 offices and.
I know.
And, I couldn't tell you how many people.
So anybody that comes through the VAB and says, hey, I'd like to have an informal, it goes to each office?
It could be, depending on,
Okay.
If you filed for an exemption in Melbourne and we denied you in Melbourne, we don't want to make you come to Titusville.
Right.
So it could be.
But you don't have like a centralized person that says, hey, reach out, you know what I mean? It's
No.
that actual branch would reach back out to the individual and say, hey, here's what it is.
No, not one certain person. No,
Right,
sir.
okay. And then,
We get 20-some thousand applications for homestead a year, so it can't
totally,
be one person.
totally understand. And then in the fact that it's geographic like that, are those geographical areas the ones that are making those decisions? Meaning that, here's my thought. They make an application, the application comes down to the central house, there's somebody internal that's reviewing them and doing it legally and everything else. They then send that back out to the other geographical area, and then they're supposed to reach out and set these informals? Is that kind of the process that you guys have?
Let's say you come into our Palm Bay office and file.
Yes, sir.
The Palm Bay staff does the preliminary review, and they make their recommendation, grant it, don't grant it. When it's not granted, then it's moved up to our Titusville main office,
Okay.
where a higher level person looks at it, and then she processes the denial, sends out all the notices and everything else.
So, but then she sends that back to the Palm Bay office, say, for instance?
No.
So the Palm Bay office doesn't know if those, so if I said these are denied, send them up to the Titusville office, you said. Titusville office then sends out all of the notices, right?
Correct?
At that time, does the Titusville office let that Palm Bay office know these were denied and this is the reason why?
No, the Palm Bay office told the Titusville office to deny them.
Okay.
So we have the Titusville office manager or whatever, look at it, say, yeah, I agree, it should be denied, let me handle
But if the
paperwork from
Titusville
then on.
office, does the Titusville office ever look at the ones that they do here and say, no, 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 and send
Oh, yeah,
them
that
back?
could happen also. Mhm.
Okay, and then they would send back.
Mhm.
But if they say they deny it and then they support it, there's some kind of communication back to the Palm Bay office that says these were all supported, these were denied, or whatever. They know. So they're not getting some random.
In our
court.
processing, in the comment section,
Okay.
and the fact that the property does not show a homestead on our records, yes.
Okay, and then that office is the one that they set up the informal with, because that's respectful because of the amount and the geographical area. They know the area better and everything else.
Well, it's not a known area, it's just we don't like to make the people drive from Palm Bay to Titusville just to talk to someone when they can
Right.
get the same answer in Palm Bay.
I agree with you
So,
1,000%.
But we do have people come from Palm Bay to Titusville to want to talk, yes.
Okay, okay.
Mhm.
Okay, thank you. I'm sorry, you guys, I'm just going through the
No,
processes
it's
a little bit,
fine.
that's all. Okay.
It's good. Okay, I think, do we have any other questions then?
I do have one other question, if
Yes.
I may. So, am I correct in saying that if the petitioner is denied by us today, he can come back to your office next year and reapply for this with all of the new documentation that he has?
He can actually do it today for next year.
Can he,
Oh, wait, excuse me, I'm sorry, March 2nd, I'm a couple days ahead. Anytime after March 2nd, he can come in and file, because we're still filing for this current year. But
So it's-
anytime after March 2nd.
As far as you're concerned, the documents, those two documents, are what got the denial in the first place?
The contents of one, the lack of the other is what's the denial.
Okay. So if he has something that fixes the content of one and has the new one, in your professional opinion, is it likely that this will go in his favor?
I would have to look at him. I would say if his documents meet the statutory requirements, yes, he would be eligible for the exemption.
Okay, thanks, that's my question.
can you apply for the exemption and go back a year? Retroactive?
No, sir.
No
No, sir.
retroactive. So, can I ask a couple of just process? And I'm sorry to keep going through.
No, no.
So, the tax, so he receives the form that says that this is your taxes. He goes in and makes the application. Then he receives the date that the special magistrate, he sent a list of documentation saying to come in. And you said, sir, that in that document that you sent to him, it did state the cardiac piece?
Chapter 196, 102 has a whole bunch of requirements, just like I said
Yeah.
earlier, that there's a statute that says driver's license, vehicle registration, voter's registration. 102 says you need certification, you need employer certification showing you're medically discharged, you need a cardiac report for 24 hours. There's several things under that statute, yes, sir.
So you referred the statute, but when the actual denial was based upon half of the first and the not showing up of the second, was any of that in there? Was he notified in any way of those specific line items?
I don't have it with, I can't tell you exactly that it said per statute 102,
Yes,
you
sir.
have this, but you don't have X, Y, and Z. I can't say that.
No,
exactly
and
said that.
I wouldn't ask you to, because
Yeah.
it's, it's not your thing, so thank you, I was just trying to figure out.
Mm-hmm.
Because what it does is if a statute is referenced, but there's no specifics to the statute, right, then you have this big thing. If they're saying specifically to those parts of the statutes, then this gentleman would say, okay, I feel like I'm here. My whole hang-up here is that, and it may not be that we can do anything, but the whole thing is that if an individual was sent a letter that said, you are being denied for this and this, and he comes and says, I've got them, I did them before January 1st, I did everything, and then they come back and say, well, you didn't suffice these other pieces, then I feel like there's a notice issue that we have in our system, that's all, that needs to be a little bit different. So if I can ask the other gentleman a couple of questions, if that's okay.
Sure.
Thank you, sir. Do you have the letter that they sent to you, since it seems like you have some paperwork with you?
I have the letter of denial, and
And the reference to this, you have the letter denial from the property appraiser with the references to the statute?
no.
Okay.
Well, hang on one second.
I can shed light on that. That was submitted by the property appraiser.
Yes, it
as
does have
evidence.
reference to the statute.
Okay, can I see that real quick? Just, because this is what I was trying to, this is the document I was
This is
trying
what
to.
I'm arguing right here, because the other statutes that he's referring to didn't come into place until after the magistrate hearing.
So it says, and I'll show it to you guys, denial of disability, okay? Employer certification of injury states applicant left first responder employment due to retirement, not disability, and then references the Florida statute. So if I'm reading that, I'm reading, okay, I have to go to that section of the Florida statute and respond to that section specifically. So he's right. And then what ended up happening is you came to the special magistrate meeting. And then upon that, they applied a series of other statutes that they are used to.
Correct.
That they are used to applying, right? I'm not saying that they're trying to be devious in any way. It's just the circumstance of it. If you guys want to see it, it's right there. Sorry.
June 27th, something like that.
That's right.
No, you'll find it on there. Yeah, you can take a look at it. It's right there in the middle.
Yeah, because they did apply the other statutes. Like I said, I wasn't real familiar with it because this was like totally new to me. And I mean, had I had known that at that time, more than likely, I probably would have had other stuff, you know, if I would have read through it. I just felt like I was nobody rushed me, okay, for one thing. I guess I rushed myself thinking I wanted to make sure I got the deadline times and dates and all that stuff.
Sir, I'll be honest with you. The fact that you read the statutes, tried to find out all the stuff, and then came back with an appropriate response is, in my mind, sufficient for what that document says. And the fact that the special magistrate says, well, you didn't suffice these other ones, and he was never notified that these other ones were the ones that he would need to protect, I feel for you. I do. I don't. And what we're trying to do is find a way that this can be fixed. Because I think I heard you sigh when she had mentioned you could go to the, appeal it, but it's going to cost an attorney and everything
Right.
else.
And I try to avoid that.
But under that application, as Mr. Thorowitz was saying, any new evidence that may come is not going to be applicable. So they would do the same thing to you there that you did here. So the only avenue in grace is what Ms. Atkinson, Commissioner Atkinson, I'm sorry,
It's fine.
responded to. I should have said that with Mr. Altman, sorry. I know people get mad about their titles sometimes, but Mr. Thorowitz, what I'm hearing you say is there is an avenue for him to go to for the property appraiser as we speak, petition her and say, hey, you know what I mean, this is wrong, and she might be able to change it before we come to seal this thing in a month? What's that?
I mean, there's nothing stopping him from making a request. That's really all I can say.
But she doesn't have to respond to it. There's no statutory, I understand that, but the fact that he's presented a pretty good one. Let me ask you this is my next step. Is there a way we can table his decision today to see if she will, and then bring it back at a later date to see if we can respond to that after that? Because that might actually it's kind of us asking her, hey, Miss Property Appraiser, listen, this guy's got a good pitch. Can you respond to this and then come back and see? I understand that the representative is inside the audience, and he is saying, representing her, saying this is what it is. But I think this man, up until now, did you try to send this to them afterwards, after the? So
What,
this
my
is
new
the first-
stuff?
Yeah,
No, because I see the workers' comp doctor twice a year. And to get an appointment today, you're a month out, 2 months out.
which is a whole nother issue.
Yeah, which doesn't really, it is what it is in today's world. But my thing is that when I found out what I needed, and I had to ask him for a certificate letter stating of my disability and whatever, and then I had myself, which I thought was unusual according to statutes, having to present it to my employer, and that's just the way the statute states it. And so that's what I did. And when I did that, she was there, read it, and she wrote me a new letter because I guess they've updated the new employer certificates, what she said.
So I think because he has not received it, the property appraiser's not received anything, for us to say that she's making a decision that she may be able to change based upon some evidence or other circumstances or something, I would feel comfortable with asking for that. I just don't know what that means, Mr. Thorowitz. And can we not have to have a special meeting to have this gentleman come back? Or can we have it at the last meeting right before we seal it up?
The board can table it to the next meeting.
Okay. I would, I think it's the only avenue I have right now to try to help you get where you need to be. Unfortunately, we're kind of handcuffed as Mr. Thorowitz, and I'll be honest with you, he's a big advocate for the individuals that come in. He's just trying to read the law.
No, I agree with that, because like the gentleman was saying, there are impromptu meetings, phone calls, and as y'all discussed earlier, would be some kind of advice, information, of what steps to take, to get this right. Would sure, it just seems like it was just so negative and nothing. I mean, that phone call was short and sweet, and
I think, so here's my thought process, if I can put it together. The individual was told by the statutory piece that we just saw that he was to define himself based upon an argument, and then it was referred to a statute that is vague, so he only had that reference to go back to. He requested and tried to make a phone call through the legal process for an informal conference. That informal conference came as a phone call that he was not able to understand, nor, from what I understand, no new evidence to it to say that you would also have to have this cardiac thing or anything like that.
no, there wasn't, because I even told her on the phone when I was talking to her that I have evidence showing that I did not leave my my employment under retirement. Because that was the whole subject when I read it, even though they state the statute there, what her definition of what the partial denial was that the employer certificate said I left under retirement.
Yeah.
That was what I was focused on. And it would have been different, if I would have I had dropped some off, which wasn't nothing, but I had more at home to show that I did not retire. And
Okay. And
there was
then-
nothing to discuss, other words, like
No, I get it.
when somebody, you would think, when you got a government agency like this, and you would think you would have a little bit of, like tutoring, as I should use, the word I would use, with somebody that don't understand, and reading some laws, it takes an attorney to understand some laws a lot of times,
Yep.
and that's, I don't know.
I got another question.
Go ahead.
Yes.
Just a couple of minutes ago, I believe you said you went back to your cardiologist and they filled out a new form? Because
No,
because I believe you said, they changed the form, so now.
No, that was the employer. They changed the employer certificate.
No, that's okay, because
That was
Trying
revised
to-
October 25.
if they change the form and does that change the process that doesn't give the taxpayer a chance?
No, the form was not changed retroactively.
Yeah.
That's just not, that.
Yeah, but it could have been so close to the end of the year that with paperwork and people going on vacations and Christmas breaks and things, he didn't,
The form itself hasn't been changed since 2019.
okay.
Now, what was on the form, I think is maybe what.
It's been, your form's
How
been
the form was
revised,
completed, because I
I got
was-
the old one and I got a new one.
One of the issues was that really frankly, your employer messed up on the form. There was an inconsistency where it said one thing and then said another thing that was a little different.
Exactly,
And that's not your fault,
right.
but it
The
was
form
one
was
of the
changed, I
issues.
think, changed based on something like that.
May I?
Yeah, that wasn't, I will say that I don't think that was truly the primary issue in this case. It really was the lack of the certification.
If I may. So feel like we have two choices here. One, we deny now, and he goes back to the property appraiser, and because he has the evidence he has, gets the decision that he wants for next year. Option two is we table it now, we let him go back to the property appraiser and give their office the opportunity to change their mind. Is that a possibility? Is that something that the property appraiser can do?
I would say they have discretion. However, just based on their opposing this through the VAB, up till today, through today, I don't know how likely it is, but I
And that's why I
think
asked
it's
him,
a possibility,
the
it's a
reason-
theoretical possibility.
That's the reason I asked if they have seen any of what he has already presented today, and he said no. And I feel like it's not fair for us to say that the property appraiser is going to deny this man without giving her an opportunity to review it. So if there is discretion, that's, sorry.
Maybe we, no, I was saying, maybe we should
Property
ask the
appraiser,
property
right.
appraiser's office. If that's something that they would even do. I don't know.
We would never steadfastly deny anybody anything and not willing to take a look at something.
that's what I
So if
figured.
you guys want to table this, I'm not saying we'll grant it, but
Yep.
we're definitely willing to look at the property.
You're awesome, thank you.
I would like to make a motion to table.
Sure.
Is-
Second.
is-
I don't know if the motion, I guess the VAB can't direct the property appraiser's office to
No.
do anything. However, we could request. Just request. Say,
That can't be part of
"The
the
guy's
motion, I don't
here,
think.
The gentleman's here,
I advise.
look over the stuff, make sure he doesn't have anything else that he needs to get together, and
I think we're saying that we are tabling it for the property appraiser's review.
My motion is simply to
I'm going to
table.
let you speak. Go ahead.
Yeah.
My suggestion is a clean motion to table it.
Okay,
Okay.
just to
And
table.
then,
Okay.
Can I ask him real quick questions, and then?
Sure.
Sorry, since we're on the piece, can you come up real quick? So you were denied, can you give me some dates real quick?
For
You were-
what?
For this whole process, just so that I can put it in here, because I've got some in-betweens that I was going to look at. You were denied on what day, do you know?
I
When
was
you
denied
received
on
your-
6/27 and 25.
Okay,
That's the letter I received stating that I left the employer certificate stated I left my employment under retirement.
when was this exchange back and forth with the request for the informal? Roughly, it doesn't matter, you can tell me.
I don't have that email with me, but it was once,
July, August?
it had to be some time frame in there.
Okay, and then the special magistrate dates, when was that?
That was October
October? I don't need to know. the
October
specifics.
20th or something like that, because it took her 30 days before I received her reply
October
or
21st.
decision.
Okay. Okay. And then you said that, and Mr. Thurwitz, you had mentioned that his employer had not properly possibly filled out the paperwork to create the trigger. And you had mentioned that the workers' comp is a difficult thing to get a.
Workers' comp cardiologist, yeah, well, yes, it's just, it's hard to get
I get it.
him to do something like that. To actually go to him, present the statute to him, and then have him write a letter to where I can take that letter and present it to the employer.
Yeah, okay, I feel confident with what we're doing. I do. Thank you. Thank you.
Okay, is there a motion on the table?
It is. I
Motion
second
to
it.
table.
Second. All in favor, say aye.
Aye.
Motion carries. Okay, we will move on to the next case, would be 2025-00103.
Is that you?
Good morning.
Sorry you had to go wait all this time, sir.
My name is Madhav Dital. I live in North Merritt Island. I have applied for agricultural exemption for our property, which we are living as a primary residence, timely filing, and I was denied by the special magistrate citing the land was not used for bona fide agricultural purpose as outlined in the Florida statutes. And I'm here to request for reconsideration based on the Florida statute 193-461. The land has been continuously used for agricultural purpose, and I'm a new owner, started November of 2024, and since then I have continued to use it for agricultural purpose. I have submitted the receipts, and I have submitted the pictures of the fruit stands that we are commercially operated. And the Florida statute 193-461 does say that bona fide commercial agricultural use as of January 1st, the statute does not require profitability, Schedule F filings, tax filings, commercial scale infrastructure, or mandatory sale receipts, but I have submitted those two. Florida Supreme Court confirms the profit is not required. However, the recommendation decision relied heavily on the absence of tax filings, lack of document receipts, and characterization as a hobby farm. I have two arguments based on the denial. The first one is, I was told that we are using that as a hobby farm, and the intent when I bought the property was never to use as a hobby farm. I have set up a nursery certificate through the Florida Department of Agriculture. I have a EIN as a LLC on that business, operating under LLC. So having all those activities, commercial activities under Florida law, I feel that the Florida law, statute 193.461 was not, had a problem when special magistrate applied that. That's what I feel.
I'll be quiet for a while. I've used up all my time already.
I think we should ask for the property appraiser's thoughts.
Let's hear from the property appraiser.
Yeah.
Good.
Have a seat, we'll have,
Okay.
thank you.
VAB's attorney's going to have to help me on this one. This one was denied as untimely, so do I need to say anything at all?
Well, that's up to you. That's really up to you, yeah.
So I don't know if this request for reconsideration is valid or not. Do you have to rule on that first before we talk, or?
Well, I don't mind saying yes, it was untimely.
Can you
The board,
explain
the board's
untimely?
rules require requests to be submitted within 10 days of the recommendation. This was submitted about a month and a half later, so it is untimely. I did go through why I thought it was nonetheless substantively correct in my memo. I'm happy to discuss that if the board reaches
Yeah.
that. But it was significantly untimely. That's a strict rule. I don't recommend making an exception. That if the board makes an exception, it's got to make an exception across the board, so that basically does away with the deadline.
What is the, okay. All right. And the purpose behind having that strict deadline of 10 days, are they supposed to, when they have that, if they have that 10-day rule, are they supposed to go back, get all of their arguments, their paperwork, and come back to that, or just signify that they are arguing this?
All that's required, I mean, they could submit more certainly, but all that's required is to identify a legal issue that they believe is incorrect.
Okay.
My understanding is that you have 10 days to say, hey, I've got a problem with this, I want it to be looked at, but then you have an additional time frame to produce all of your information and all of your supporting evidence. for
The
your
evidence
case.
would already be in the record at that point. So the request process happens, well, let me back up a step. So first, there's the hearing. At some point after that, within 21 days typically, the recommendation is issued by the special magistrate. Within 10 days of that, if either party disagrees with it, that's their deadline to submit a request for reconsideration. So at that point, any evidence has been in the record for quite a while, at least a month or so.
So you're well into the process as the petitioner. You're well into.
You're really, the whole process is behind you.
And then, in this case, he did not, so you have the hearing, then they had the 21 days to respond, the 10 days to say that, 21 days to respond to say this is what the decision we're going to make, the 10 days on the deadline for them to argue to make the reconsideration. And then, what is the process after that? They say, we do want to have this reconsidered, and then they come here, or?
Within 10 days of the recommendation being issued, they submit a written request for reconsideration. After that, the other side responds, I believe within 10 days, and then ultimately it's heard by the board like today. Just to round it out a little bit, these cases are about whether it's a bona fide commercial agricultural operation. It's not absolutely required, but typically financial documentation is a key piece of evidence. In this case, there was none. I don't mean a little, there was none. The only documentation submitted by the petitioner was a copy of the statute. So, again, that's not in and of itself dispositive, but without any financial document, there's no Schedule F, which an agricultural operation would have to file with the IRS if they're a bona fide, if they're an actual operating business, that would be required. It's a, federal law. There was nothing, there wasn't that, there wasn't anything else. So candidly, this was not a close case.
I have a question. I'm just curious, in reading the report, it states that the petition's concerns of denial of agriculture classification, the special magistrate recommended denial, concluding the petitioner did not establish by a preponderance of evidence that the property was being used primarily for a bona fide commercial agricultural purpose as of January 1. It doesn't say anything in that initial statement about filing late.
I'm not sure what,
This is 103, isn't it? 2025-00103. It didn't really say anything about, and then it goes into the issues. It's not clear under that
I
report.
think that's my summary opinion
Okay,
in the,
but it wasn't denied because it did not establish preponderance of evidence. You're saying it was denied because it wasn't timely?
no. I'm sorry if I misspoke.
Okay,
The request for reconsideration was untimely. Nothing else was untimely that I know of. The request for reconsideration that's before the board right now, it was
Oh.
submitted approximately 6 weeks after the recommended decision. 10 days is the deadline.
So this
oh,
is just
so it was,
strictly about-
right, it was
So
untimely.
really, the board shouldn't go past that issue. But I'm here to say, even if the board did, it was not a particularly close case on the merits. But I don't
Okay,
think the board
understand
reaches
now.
that. Sorry. I
Okay,
should
no,
have-
that's okay, I understand. That clarifies it. So you're saying that that we have an issue of untimeliness and that,
No, I mean, I don't mind him responding.
pardon me?
If he wanted to, I was going to ask him
Yeah,
real
yeah.
quick the processes and stuff like that, if you can.
Yeah,
So if the request was.
Can you go through the whole, can you go,
10 days.
can we go just real quick, run right through it? So you received it from the property appraiser that they were going to deny yours.
Yeah.
You then said, okay, upon that letter that this gentleman had, it stated some things inside of there that said that you are being denied because of this. And then you brought that to the hearing, correct?
Uh-huh.
And then from the hearing, they found 21 days later that they were going to deny you, and you had 10 days to come here. Is that correct?
10 days to submit the request.
Okay, I just want to make sure the timing was there.
Yeah,
Okay, now
so
go.
so everything is new to me,
Yeah, it
So
is. It's the problem
that's
we
one
have.
thing, but that might not be enough thing for me. But what I did was, once I was notified that I was denied, I re-engaged with the VAB office, and this was November 19, 2025. Upon receiving the denial on November 19, 2025, I immediately contacted the VAB clerk requesting guidance regarding deadlines and rights. This demonstrates the intent to comply. I did not get the answer of, hey, we have to apply within 10 days. I did not get that. There was a communication. All I was provided was a link. There was just one link, that's all. It didn't say 10 days or 12 days or anything. I didn't know that part. Had I known that, I would have immediately met the deadline. That was my argument on that time.
why this
I
is-
have, my intent was always there, because the moment I received email, it did not go past 1 hour for me to respond to that VAB email. And I got was the link. And the link, even going through the link, I could not find the 10 days anywhere, and that was brought later in the case. Why did not I was notified, hey, you have to do this within 10 days? Because my question was, what are my rights? What I have to do was my question. I did not just put vaguely, I asked the guidance on that one. Why didn't I get the guidance? Why didn't I get, hey, 10 days, this is this? I would have responded in hours, not even days, So that's my argument. And obviously going through this kind of things first time is a different ballgame, Now, if I have to do, next time I would know. But the intent is there for me to respond. And I have all the emails that I contacted the VAB office, and the email clearly didn't give me the guidance, just gave me the link. So that's my argument on that late filing. It was never intended. It happened that way because of the poor guidance.
Yeah, ma'am.
Chairman, so yes, we're not allowed to give legal advice, so we did email him the link for him to review the request for reconsideration procedures on his own. And 1.1.5 gives the timing of the request on the first page, so that's why we did what we did. Because we're not allowed to give legal advice, but we did advise him of the link in Word defined so he can read it for himself.
So you provided him a link to that?
Yes, it's on our VAB webpage. It's under file a petition, and it's under the local procedures. So it's on there 2 or 3 times, but I went ahead and just sent him the link so that he didn't have to go look for it. He can just click on it.
And you said the deadline is on, where is it?
1.1.5.
No, I know, but where is it notified that, when does he receive, besides the link, something that says you have 10 days to respond?
When he called and asked, that's when I knew to send it to him.
Okay. But you weren't able to tell him the 10 days, you just said, here's some rules and
No, sir, I
regulations that
cannot.
you have to. In other words, we don't allow like the statutory laws to be sent out and say, hey, you have 10 days for this, or no? Because then it could be construed a different way.
Yeah, the clerk cannot give legal advice, even something like that. It's a bad practice to even open that door a little bit.
Okay.
And, it's a legal question. What is my deadline? That requires legal interpretation. It may be simple in this case. It's maybe not the best example, but the clerk did the right thing here.
Okay.
Okay, so I think maybe we have 2 decisions to make here. One, first, is do we decide we want to allow this to be heard, even though it was untimely? Sounds like we have that option. It's been recommended that it might open a little bit of a Pandora's box, but it sounds like we do have an option if there's certain circumstances, I think. And that would be our first decision. Our second decision is then review the case on the merits of the issue, which is also, well, obviously it's denial because he wouldn't be appealing at all, but, so that's where we stand.
Mr. Thorowitz, just a question. Pandora's box, can you tell us what that is, just so we understand?
What I'll say is if the board disregards the deadline in one case, there's going to be an argument in every other case that the same thing has to be done, or you're not giving due process across equally.
Could that
And I
be
could also,
retroactive, too? I mean, that'd be a
maybe,
stretch.
yes, I think it might, that there's an argument that it could be. Additionally, I think it's foreseeable that there could be a complaint to the Department of Revenue. Just, got to advise the board of that. That we're not
These are
following-
all reviewed by the DOR, right? Department of Revenue?
Not really, no,
No.
not each and every one.
Not each one, but the,
If the
but
board
the
is not.
tax roll, I guess, is reviewed in the process. It's more of an audit. They may pick out certain things, they may not. But not each and every one. Okay, that's good to know. Okay, so,
You're saying that, and again, I'm just running through this process. I didn't hear what you said. Can you repeat what you had said?
Who, me?
Yeah, you stated something. I couldn't hear it because I was behind here.
Oh, retroactively, the Pandora's box question was what, like he said, if you open up the 10, or if you blow out the 10-day requirement, for one, you have to do it for all. And then I asked him, I said, and could it even go back retroactively? So like somebody who had a request denied in 1999 because of the 10-day requirement, and they could now, honestly, I don't know how they would hear about it, but they could. And then you could open up the dam,
Unless we put like parameters and say he responded within a certain amount of time with the intent to do this, but was, blah, 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 but
Yeah.
can't do that thoroughly.
I wouldn't recommend changing the rule
Okay.
sort of ex post facto.
Yeah. Okay. What are you thinking, Commissioner Atkins?
My thought is, I don't like the process. I don't like how it doesn't work for people who don't know. But I sure don't think that we should change the rule of a 10-day response time. I think that's very dangerous.
Respectfully.
Yeah.
The process works the way it's supposed to in almost every case. And the way it's supposed, and what I mean by that, a request for reconsideration is not something that should be done in each case. It should be the exception by far, because it's really only for when you see that the special magistrate has misapplied the law. That is a rare occurrence in reality. And the rules, these are rules which, I wouldn't say most, but many VABs across the state have adopted similar or nearly identical rules, and that the Department of Revenue has, I'm not going to say they've approved them, that's not quite accurate, but they've been attacked in various ways, and they've never been, the department's never sustained any of those attacks.
Yeah.
So the rules themselves appear to be valid by all measures.
The rules, sure.
Yeah,
But
so-
the resident going through the process,
That's,
that's my problem, it could be made more user-friendly, I think. But in this particular case, we're talking about filing timely. There was a link that was given to get there. And for me, again, ignorance is not,
that's why I brought all these forward.
yeah. That was not a complete thought, and I apologize.
The link was to the request for reconsideration rules. The rule regarding timing of requests, it's as clear as possible that there's a 10-day deadline. I don't know what else could be done other than that. And I wouldn't recommend asking the clerk to go further than that, because again, that's like disregarding the 10-day deadline. It's very difficult where to draw the line when we do things like that, or when the board, does things like that.
Okay.
Can we get I know you showed us a piece of paper that, can you let us look at that? That'd be helpful.
I have to put this, if it is possible.
I think she's got the same.
This was
thing.
included in the email as
Okay,
well.
thank you.
You're welcome.
Yeah. It basically reads, it's on the front page, it's toward the bottom, second to last paragraph. Timing of requests. Requests for reconsideration must be received by the Value Adjustment Board clerk not later than 10 calendar days after each party receives notice that a recommended decision has been filed. Petitioners who have designated U.S. mail as their preferred contact method must provide the request for reconsideration no later than 10 calendar days after the timestamp on the special magistrate's register decision.
No, it's on the first page.
It is. It's a lot of words, but
Yeah, I get it. And that's exactly how it comes,
yeah.
if it does. And I think all of us are sympathetic to the people who are here today, you know what I mean? I think that's not a question. I think it's just the process of how, and that's why I brought these changes today to talk about a little bit.
Yeah, and I'm also pulled up the petition, the form, and I assume this is section 194.011 Florida statute. I would assume this form was probably developed by rule. It is 12D-16.202 Florida Administrative Code, probably by the Department of Revenue. Petition to Value Adjustment Board request for hearing. On that form, it's not real clear. There is I haven't even been able to, maybe it's here, I just quickly reviewed it, been able to find where they actually set forth the 10-day.
That's not it wouldn't be on that. That's a local procedure. So it's not something the DOR promulgates.
Oh, really? Okay. It does say, okay.
And that's developed by the state or developed by the county?
The reconsideration rules were adopted by this board.
Right.
Oh, okay. It does say, final paragraph, other assessment appeals, the petition, for petitions on the denial of a classification or exemption are based on an argument that the property was not substantially complete, January 1, all at non-ad valorem assessments and the amount of the ad valorem taxes, the taxpayer amount in good faith, less, okay. I don't think there's anything on this form. And the question is, and I don't know if that's an issue, this is not directly only related to this request, but is there a way that we could better notify
Right.
the consumer, the taxpayers?
That's what I
of
put
their-
together and, yeah.
Pardon me? Of their rights?
Yeah, they, I'm not sure if you guys saw the piece of paper that was here that Mr. Thurowitz and I were working on. This was what I felt like at the last meeting, is that I felt like there was a bunch of different areas that we could increase education and opportunity
right.
for the right decision-making. That's where this was. It's funny that we have everybody come in on the day this is. It's almost
Yeah.
like it's planned.
Exactly.
But I hear you. Who developed the form, though? That is that's not the local VAB or those, it's the state?
Which form?
The form that he's looking at currently, that is the form
that
they
the
fill
petition
out.
form?
Yes.
That's a DOR form.
Yeah, that's what I figured. And
Yeah,
on the
state.
DOR form, it doesn't have any of the rules and regulations. That should be a secondary form that we tell them the rules, right?
For reconsideration?
Yes, yeah.
Yeah, that would be
Okay.
something the board issues.
Okay.
And that's something that would be separate from this petition if we're trying to
Correct.
make it more user. Back to this petition. I remind everyone too that it was untimely, but also it was denied. So we may not have the option to, or it may not be desirable, our council's recommended that we don't make an exception, but certainly we could, as a body, look at these issues of taxpayer notification, just to make it more user-friendly. So we understand your point. Unfortunately, we may not. Do you want to show us that form? I know you,
I wanted to show this, really.
okay,
Yeah.
You can give it to the chair. He can disseminate it however he wants.
okay.
That DOR forms statewide, it would not have our local rules, because they're all different. You know what I mean? So-
Okay, do you want to explain to us what you've circled?
Yeah, the circle means immediately after I received the denial, I asked those three questions. And those three questions straightly says, let me know if any statutes or time deadline runs out. So.
And what
it
they
was-
did, when you asked all good questions, they responded by giving you the link to the statute. Okay. And this is the document that we have here. Local procedures for requests. And this is straight from the statute. Is this statutory language? I don't know.
Those are the local reconsideration procedures. That's adopted by the VAB, this VAB.
Okay, we could probably make these a little more understandable.
That's what I was
Yeah,
getting at.
yeah. That's incumbent upon us, so.
So this seems like
This is
something-
ironic that
You can
this is,
stay right there. We, this is a form that you sent back to the VAB, and is that, this piece of paper right here is, you state right here,
That's an email.
when did you send this back? Yeah, it's an email. When did you send this back? Was it within the 10 days?
December 19, oh, sorry, November 19.
Is that within the 10 days?
It was hours right after I
No.
received the denial.
The denial.
Yeah.
And then when you sent this to her, you guys sent back a link. And inside that link, it formulated everything that he's supposed to do in the, is that, Mr. Thorowitz, you want to, you
The
got
ma-
something to say?
Yeah.
The magistrate's recommendation was issued October 25th.
Okay.
So that was over,
So the hearing
about a
was
month
before that.
later. So that was well over 10 days later.
So it's outside the 10 days.
Oh, yes.
Can you explain that? He's saying that you received it, you received the notice that you were denied, Mr. Thorowitz.
October 25th.
On October 25th, and you're stating that you sent the email November 19th or something?
The date I have is November 19 for the denial from the VAB.
So he's
So
saying,
he's saying November, you're saying October.
he says he received his denial on November 19th.
The date
I
I'm
got from
showing,
VAB at brevoortclark.us. That's where I got from.
Can you
Actually, it
guys
shows
verify all
a
these
different
dates?
date. I will add, either way, that
I know.
request is still quite on time.
I'm just trying to figure out, again, process,
Yeah.
what, those dates that he said, do you have the timestamp of, or do you have the timestamp of when that email came?
I
Did-
have the
did not-
email I can print.
What they sent you, because there seems to be some kind of a, like, you're saying you didn't receive the denial until November, he's saying you got it in October. Where's the difference there? Is that right?
Yeah, our system shows that the recommendation was issued October 25th.
And that's issued in what way? Sent to him in an email?
Is that emailed to the petitioner?
Again, the process.
Once the decision has been rendered, we mail and email everything out. So it looks like his was actually emailed out to him on 11/20 or 11/19. And he had 10 days from that date to request a reconsideration.
It says October 25th.
So on 11/19, he received it and then responded back with the request of all of that. And then in it, it said, can you tell me of all those dates? And you sent, I'm not going to be in the middle of this, you sent a link to him?
Yes, I sent the link to him. Whenever he emailed or called and asked about what his next steps were, I referred him to the request for reconsideration because I cannot give legal advice. He had to take that upon himself to read through it to see if he met the statutory requirements for what was going on in those requests for reconsideration procedures.
And what is the official request for reconsideration form or way that he does that? How does he notify?
There
him?
is no form. He just emails us the reason why he feels like he was denied, and then we forward that on to the property appraiser, and we also give it to Aaron, and Aaron makes a decision as well. And he
So
did that.
the email that he said he sent, within how long, an hour or two afterwards, that is,
Yeah, it says 11/20 here in this form from BAB though.
it's okay, you're clearly within the 10 days on your email. But you emailed what you just showed me, which is still within our right of evidence, right? To the VAB, correct?
Uh-huh.
And that's that form that you sent, that you just showed me was an email you sent to Ms. Nicole, and then she emailed you the link. Is that the process?
Yeah. Procedure is what it means, yeah.
If you read that, it looks like he's trying to say, I have an issue with this. Can I see that again? And that's not what I need. I need the other form that you have.
It's not a form, it's an email.
Email, I'm sorry, the email.
I didn't print the email,
The one you just showed us.
You just showed me something. It had a big circle on it.
Yeah, this
Questions.
one,
Where was this, when did you make this and where did this go?
this was from November 19.
And did you submit this to them in an email?
Yeah.
Okay.
Those are the three questions.
So you received, Ms. Summers, you received this, and then you sent him the link?
Yeah.
That's what, I'm sorry, yeah. Sorry. This thing goes.
I don't have that. I don't have that. Was this it?
That was sent way later. This was
Way later,
sent
yeah.
December.
After the 10 days.
31st.
Yeah.
Do you have the date on it? December
31st.
30th? Hold on.
December 30th.
December 30th, yes.
That's when this came.
Mhm.
This came, yes, after the fact. The very first, I don't know if it was an email or a phone
I
call.
think it was a phone call.
And then we sent him
Yep.
the link
Just
to
say,
go
hey, here's
look
how
at
you
the,
guys can do it.
the request for reconsideration and the local procedures
Yep.
to see what we do.
Yep.
And we leave that then up to him
Absolutely.
to decide how he's gonna handle it. If he didn't respond within that 10 days, that doesn't fall on the clerk.
No, I know. I just didn't know. He was stating that this is what he sent.
Oh, No, he
within the 10
did
days.
send that, but he did not send that until the December 30th emails that came.
Yeah, I just was trying to get clarification because in here it states that he's, so you didn't send it on the 19th. You sent it on sometime in December is what she said. Okay, I'm good. Again,
May I ask a quick question?
Yes.
Mr. County Attorney, could you possibly articulate the question that is before us right now?
Whether the request for reconsideration was submitted within 10 days of issuance of the recommended decision. And if so, it's timely, and it can be considered on the merits, and if not, it should be denied.
I'm good. I've sufficed myself. Whenever you guys are ready to roll.
You ready to make a motion?
Oh, yeah.
All right, let's go, let's hear a motion.
Yeah.
What do we, might as well bring it.
Oh, that's right. I'll move to approve the recommendation.
Okay, there's a motion to approve the recommendation. Is there a second?
Second.
Second. Any discussion on the motion to approve the recommendation? All in favor, say aye.
Aye.
Carries unanimously. Okay, thank you.
Okay.
Thank you. We certainly understand your situation, and we may make some corrections here
Yeah, we-
in the future.
We appreciate what happened. Unfortunately, we have the laws of the 10 days, and our clerk did a good job of sending you the link, which we understand because of laws and everything else, but it's difficult because you were denied, and then based upon the time frame was not followed. I think that's where I felt my judgment was, so I appreciate it.
The last point I want to make is, I was told this was sent on December. It's not December, it's still November 19th. And I'm doing live.
Yeah, no, she sent that to you on the 19th, but they need intent based upon their link that you are going to argue against it and you want a formal, hearing in front of us. They're saying they did not receive that within the 10 days, and they're saying that that form that you showed me was not sent until December, which is after the 10 days.
Okay.
So,
Okay. Thank you for your time. All right, we will go to the next item, which I'm trying to pull up here. I've been looking at statutes and, okay, what is our next item?
believe it's,
I've lost the
board
agenda
reports.
because I pulled, oh, here it is, I got it. The next item is 2025-01297.
I don't
That
think-
was removed, sir.
Yeah.
That was removed.
That's removed.
Okay, good.
how do
Oh,
we go
I'm
about
looking at the-
removing them, since we've got a couple of them? Is there a process that you guys say that they have not signified that they're coming in? Is there another, go ahead.
I can take that. There was a notice issue on this one. I think, if I'm remembering correctly, the property appraiser, there was a typo on the email. It was not the clerk's fault. It was not the clerk's typo, just to be clear, but it was misunderstood that the property appraiser, we thought that they had received the request for reconsideration, but there was a typo in George's email address, so they in fact hadn't. So we wanted to give the property appraiser their fair opportunity to respond to the request before it came before the board. That's why it got
So
removed.
this one will come to the next meeting?
Yes, sir.
Okay. Okay.
Okay, so that concludes all of our appeals. And we now move to board reports. And the board attorney, Aaron?
I'll be happy to comment on Mr. Seuss's.
You want to give everybody else time to go through, and then we can end on mine, just so that they get.
Yeah, I don't
whatever.
have an independent report, though.
Okay, but is this where we would do this? Under the reports?
Yes.
Okay, let's.
Okay.
Sure. So the board has before it a short memorandum regarding some ideas for ways to potentially improve. I don't know if I'd say the reconsideration process. I think it's more informing the public about the reconsideration process and maybe clarifying some things about it. It's not proposing any changes to the rules. It's really just trying to make it as clear as possible. One possibility would be setting the date of essentially today's meeting well in advance, potentially at the organizational meeting, which is the first meeting of the tax cycle each year. I understand there may be some logistical, practical issues with that, just due to reserving this room. I don't, that's something I don't really know much about. But doing that would enable the board to notify the parties really from day one of the date of this meeting, so that if they do have something that they want to bring before the board, they'll have as much notice as possible of exactly when and where that will be.
So when I called Mr. Thorowitz and said, hey, let's work through some of these, right? One of the things that you always like to do is say, here's a series of deadlines. And if we say the deadlines are the 10 days and all that stuff, that's great. But if there was a way that at the beginning of the year when we come in, we establish a series of dates, you can put those dates on there to signify when they are. Now, because of Mr. Thorowitz was saying, you may have a change based upon something, which would throw that whole notice off and cause chaos, then having those dates in advance somewhere on there would be good. But having a tentative dates where we know we are meeting way ahead of time. I mean, if we look at our calendars and we say, yes, it's open, and this room is open, and we know these dates, then we could plan for it a year out. That was my original theory. But putting the dates on the website would be dangerous, but putting the deadlines on them. So the request was, if we could establish our dates ahead of time, then individuals would know, like at the board meeting when they come in, that, hey, they have one scheduled for this time, you may want to look, but your deadline is this. You know what I mean? There's a definite notification that's a lot better than just saying what we have. That was the reason behind it. I don't know how you guys feel about trying to establish a calendar ahead of time. And I don't know what the clerk would recommend also, what your feelings are on that. If I could ask you guys, because you're the ones that are always putting it together, right? But if we sat down with all of our calendars and,
Well, okay, so first off, outside there, they don't let us schedule this room a year in advance because they have to wait until they get all their meeting requests from county employees, the Board of County Commissioners. So they have that whole schedule, and then before they'll allow us to go ahead and schedule this room. As for the rooms upstairs, I'm not sure. The Florida room, Space Coast room, I don't know about those rooms, if they feel the same way about those rooms. So that would be the first concern. Second concern would be, Aaron, being an attorney, I don't know if he can do that a year in advance and be like, if he gets scheduled for a deposition, or whatever the instance is there, or a case, I don't know how that affects him either.
It's not an issue really for me.
Okay.
Honestly, more advance notice is kind of helpful. But one potential problem I could foresee, if the board sets a date certain as opposed to a tentative date and then changes it, that will cause confusion. So, there may, and the board already does set tentative dates, but that's all they are.
What would happen if we set a date and then we didn't have quorum?
Wouldn't have a meeting.
But setting a date far enough in advance would be better,
yes.
would probably possibly more ensure that we had a
And if you did it tentatively, then it is the same retrospect as that. Do you know when the county actually says, okay, now you can schedule all? Is it a rolling calendar where they're like, next month?
It's after, I believe it's after the Board of County Commissioner approves their calendar for the following year, then they can mark the board's.
And that's usually in like November?
did that, didn't we just do that?
I think so, yeah.
It wasn't that long ago that we just did that.
So that you
But
guys
the
just,
hearings don't start until October for, say, the next year. So we start the hearings in October, so October, November, December, January, and we try to end it sometime in February, beginning mid-February for the hearings. So this year, what we did was we took whatever we had up until a certain time, if we received any requests for reconsideration, because we still had hearings going. So those people still haven't, there's several people who still haven't gotten their recommended decisions yet, and to have their 10 days, and so that's kind of why we're still back in the process, but we were just trying to figure out what this hearing was going to involve.
And the other thing, just to add to the confusion, is that it's not necessarily going to be we two commissioners the next time.
That's
So if we try to base things on our calendars,
Right.
you could be dealing with
That's true.
other commissioners.
okay. No, that is a very good point, because we would establish the dates based on my calendar. And then all of a sudden, because I think Megan's taking over next year. So the argument is that it would have to fall on her calendar. Now, we would be doing it so far out in advance that, you know what I mean, they would know the conflict coming in immediately, but I can see where that's an issue, you know? Yep. Okay.
One
makes
other
sense.
idea, and this is done by some VABs, but by no means all, and maybe this is done to some extent, I don't know already, would be, and I don't know how practical it is, but maybe including the link to the reconsideration procedures along with the recommendations, I don't know if that's a feasible thing to do.
No, there's a lot of these. There's a lot of those that I have in here, but I think as far as the dates well in advance, I think we all kind of found that that's probably not going to be able to go because of the
It sounds like a
schedules.
really good idea and smart. It might not be logistically.
Sometimes you put them in like the third Tuesday of this and the
Right.
fourth Tuesday of that and all that stuff, and everybody just knows. It's been legally noticed. You are signing on as a board member. You know these are your dates, you know what I mean, and all that stuff. But I'm not willing to push it if you guys don't feel comfortable with it. One of the things that individuals would really need is I know my dates, because if we do ours about 30 days out. Is that where we're at? Like for this meeting, we all agreed about 30 days out, 45 days out? How long?
I don't know.
Roughly, like 30 days?
30.
So it's difficult for their calendars also to land on there too. So if we agree to it, then they would have to contact to try to figure it out. That's why I was trying to figure out the dates ahead of time. So if they know, look, when I come here and I get denied, I've got my 10 days, this is what I'm doing and everything else, then, and those dates they know ahead of time, then they're more likely to be able to defend themselves and be prepared, rather than we set our dates 30 days, they have to call in to figure out when it is, that's all. But I'm not going to push it if you guys don't feel comfortable about it. Not, Mr. Thurwitz, you want to go with the other ideas?
Yeah, the other ones are really just putting it in front of the public as much and as visibly as possible. I know it is already on the website, to be clear. It could be made more prominent, I suppose, and then, relaying the information to petitioners when they receive the recommendation. To me, that change, if it's feasible, it's probably about as much as the clerk can do legally.
Right.
And that's what some other, not many, but some VABs do, is something similar to that. The information is already out there. It's really just a matter of how prominent it is.
I almost feel, I'm sorry.
Go ahead.
I almost feel like we have people who are involved in the process who understand it completely. and it's just second nature. But for other people who are coming in that have no idea how it works, and don't even necessarily know where to look for the information. And when we send an email asking for help or guidance, we can't give it. So it's almost like we're forcing people, no disrespect, to get a lawyer. You know, like we've said, we don't have that many people who come in here without representation. I don't know, I'm just,
I think we just had two cases where the individuals had difficulty in different places of finding the deadlines, finding all of those components, right? I think it exposed multiple ones that I actually had in here. And I think that for us to sit there and say, okay, on the website, we're going to do this, on this, we're going to do this. What I would really love the opportunity to do is if you guys feel comfortable, the goal is to make the meeting notices and deadlines more prominent on our notifications and make sure that in all legal paperwork that we send out, that it's included in bold and prominent. That way we have no questions as to, and even a process that we might want, that in the event that the property appraiser is going to make an argument, like what happened with this gentleman, that all of the arguments are inside there or a way for them to find out what's available.
Yeah.
If you guys, I know that's a very vague area, and we don't have hours to sit here and go through it all. If you guys would be okay with it, I can sit with, the goal today was for me to say, hey, guys, we could use some better pieces. If that's okay with you guys, I would like to work with Aaron, make some of those as a recommendation and bring them back to you guys at the next meeting.
I fully
That's a
support
great
that.
idea.
Yeah, and then
I'd
that
vote
way
for
we
that.
can, and then you guys can say yes and no,
Yeah,
and go from there. I think that would be good.
I don't think we need to vote, we just
Yeah, no, that's just-
acknowledge we approve that.
Direction.
That's
Is-
good.
Is that okay with you, Ms. Salwitz?
Of course.
Okay,
Cool.
thank you. That's it.
Where's your office?
Thank you for doing that.
Okay.
Yeah, spent a little bit of time going through it. And just so you guys know, everything that I did when we made those recommendations to bring, I thought it'd be a little bit more conversation, but thank you for giving me that. The other thing is that it is in the same, in other VABs. So I looked at Miami-Dade, Polk County, all of them. So there are instances where there are some more prominent notifications and processes. So thank you.
No, you're right on it. Thank you for that. That's great. Okay, I have no report.
I have no-
No report from Commissioner Atkinson. Matt, you have a report?
No, sir. Thank you for giving me the opportunity.
Robert?
No, sir,
No
I'm good.
report. And Bob's not here, so I think that's our meeting.
Thank you.
Well adjourned. Good job.
Thank you.
Honored to
The opinions expressed by any member of the public during any period of public comment do not necessarily reflect the views or opinions of the Board of County Commissioners of Brevard County, Florida, Space Coast Government Television, or the program sponsor, and are solely those of the presenter. The Board of County Commissioners of Brevard County, Florida, Space Coast Government Television, and the program sponsor hereby expressly disclaim any and all responsibility or liability for any defamatory or slanderous statements expressed by any member of the public during any such period.